It's 8:30 a.m. on the 26th of January 2021. And would first of all, Commissioner Jackson usually chairs this committee, but he was unable to attend today, so I get those duties, and we'll go ahead and get started. And Denise, if you'll just call roll for the Legal Review Committee, so we'll have it documented who's here.
I will do so. Commissioner Galvin
Here.
is present. Commissioner Kramer
Here.
is present. Commissioner Jackson is absent. Commissioner Norton
Here.
is present. Commissioner Levy
Here.
is present. Mr. Chairman, you have a quorum.
Okay. All right. We can go ahead and get started. And if whoever wants to go first can start going over the legal review and making their points.
Mr. Chairman, if I could start out by reading a statement of necessity for the committee,
Okay.
so that we get this committee on the record as having read that out. I'll just read the paragraph real quickly.
Good.
That will be part of our minutes. That this is a regularly scheduled meeting of Tennessee Motor Vehicle Commission. It's taking place by electronic means utilizing WebEx teleconference application on today's date, Tuesday, January 26, 2021. Notice of this meeting was properly posted on the board's website. There is not a physical quorum present. A statement of necessity will be read into the record and filed with Secretary of State's office as required by statute pursuant to 844-108B2, which does state that if physical quorum is not present at the location of the meeting of a governing body, then in order for quorum members to participate by electronic or other means, the governing body must make a determination that necessity exists. A determination must include recitation of facts and circumstances that are based on 844-108A3 that defines a necessity as matters to be considered by the governing body at that meeting require timely action, body and physical presence by a quorum of the members that is not practical within the period of the time requiring action and participation by a quorum of members. Electronic and other means of communication is necessary. The purpose of this meeting is for members to attend teleconference to address regularly scheduled members of the board. Due to the pandemic regarding COVID, there's been a restriction of the inability to create physically present meetings within the state for purposes of safety for all involved. This is also supported by the governor's executive orders, which touch in a similar matter and fashion. And as such, this meeting will be taking place by electronic means, and all voting will be conducted by roll call vote. Thank you, Mr. Chairman.
Thank you. Okay. Who wants to go first?
Commissioner Norton, I'll go first. First, let me say my compliments to the staff for putting together today's legal report and my 6-year review. This was a very clean report, even in light of COVID and the COVID-19, the pandemic creating delays and increasing the number of complaints. And saying that, I have very few addresses to deal with this morning. I only have two and then a question. And I'll make it real simple. So oddly enough, I have 148 complaints and represents it's case 33 and case 34. So they're back to back, oddly enough, out of that range. And on 33, the staff recommended a letter of warning, too many temporary tags. This dealer had another citation in 2016 for issuing more temporary tags. And in this particular case, they issued that there was issued a letter of warning for too many temporary tags. It's my first to see a warning on a temporary tag. So my question is, why is there not a civil penalty on this one as well? Seems like to me this dealer doesn't seem to get the temporary tag regulation. So that's a question to the staff. Should we not fine them?
Thank you, Commissioner Norton. This one is mine. And I just thought because of the situation that maybe we should do a letter of warning, but I am open to amending that to I guess it would be if the commission feels like this is not a situation that could have been avoided, then I would say we need to bump that up to, since it was just one additional temporary tag, it would be $1,000 civil penalty for a second time violation.
Well, and of course I'm sympathetic. I mean, we have 6,000 transactions a year, and we dealt with that. And a lot of states were very brutal. So the ones that were closed, but still, nevertheless, we stayed in the guidelines, and everyone should. And even though that was a tough time, I mean, we have to stay within the guidelines, because I mean, there were many deals that we couldn't resolve, and we A, had to put the customer in a rental car, or B, give them their money back. I mean, that was tough, but that was the law. And I just feel like, even though there should be leniency, I think the governor allowed that in his extension of the temporary tag program. But I don't think that we need to set a precedence by waiving, feeling sorry for someone because of that. I think we need to stay within our guidelines of what we're regulate. So my recommendation is we serve a penalty. They were outside the guidelines.
Okay, well, then I can amend my recommendation to authorize a $1,000 civil penalty for one extra temporary tag allowed outside of the law.
Everybody else feel the same way?
Agreed.
I agree.
Okay. Thank you for that.
Can I ask one question on that before we move on, though, because it ties into my question I had on number 13. I think there's a typo. I think it was one. I think it's been one more than allowed by law. But that penalty is $500. Is the difference here that this is the second one, and then number 13 it was only one additional?
Yes, that is the difference.
Okay. Then I would just recommend fixing the typo on 13. That it's one more than allowed by law. But agree with Commissioner Norton on his points on 43.
And not to dismiss that, what we all been through as dealers, as far as having to deal with delays, because a lot of the county clerks were closed. And I understand that. It was hard, and we're still dealing with it and a lot of issues. But still, we're commissioned to regulate, and I think it's not up to us to use discretion on what the governor allowed for extension. So I think we're within our bounds to do this. So I don't feel bad. Number 34 is something that I just it's a question of range. This particular case is related to a customer going to a car lot, and at some point in time there was a decision made, and it's always unclear as to the trade-in, whether they should trade the car in or leave it as sitting outside out back and wash their hands of it. And all of a sudden the lien holder's got an issue. They're looking for a car and they don't know that happened. This is what happened here. It didn't illustrate. The consumer played dumb. The dealer obviously bears responsibility because they implicated themselves of knowing there was a trade-in. It was obviously on another deal. But I deal with this time and again because we have a related finance company, and we have about 10,000 customers. So from about once or twice a month, I get a notification that some unscrupulous dealer, and it's not just independents, it's franchises as well. Some even here in Franklin, Tennessee, where they basically say, your car is here, come pick it up. So they didn't enter it as a trade-in. So my question on this is a common problem of deception. And it could be just a credit issue, but the authorized civil penalty is $1,000 for engaging in false, fraudulent, deceptive practices. My question is to the staff, and I don't have the grid, what is the range of penalty on this particular violation?
Commissioner Norton, can I stop you for a second? Which number are you referring to?
It is 34. It's complaint 202-0074611.
Okay, I think that I must be looking at a different version here before.
It fell under complaint 34, but there were several other complaints listed under this one without changing case numbers.
Is everybody else seeing the same thing?
That's not my 34.
Yes, Mr. Norton, that's not R34. I'm looking for your number now.
Okay, it's 202-0074611. Did we get an addendum to the report?
I have that 74611,
Number
That's
46.
number 46.
Okay, I got it. It's under, mine falls under the heading of 34.
This one would be yours. It's the third one down on number 46. I'm sorry to interrupt you, Commissioner.
No. Thank you. Thank you very much. Make sure we get this right. But the reason I brought this up is it's a common problem, and I see it and I hear about it, and it is a deceptive act, and it's just wrong. and it affects a lot of people adversely. Credit, loss of monetary, and my question is, what's the range on the penalty of something like this? Because we may get into it, it may increase over time because the subprime market's grown so big. Stuart, are you there?
Yeah, I'm here. It starts out at 1,000. I'm trying to pull up the schedule, the citation schedule that we have. And on deceptive, it starts out at 500 per issue, and then goes to 1,000, and then, or the second time is 1,000 per, and then after that it goes straight to a hearing. So
Okay.
so it ranges, but here we had several issues going on with this respondent, and hopefully they have taken care of the problem.
Okay. That answers
It
my
seems
question.
like it seems like just everything kind of hit all at once.
Right.
And I think,
Right.
I
My
think
question,
it really has to
we're
do
gonna
with
see this
employees.
again. My question was just the range, so I'd have an understanding of our remedial opportunity there. So anyway, I'm good. I'm good with the recommendation. Okay.
Is that it for you, Stan?
No, I got just one last. It's a question. It's not
Okay.
a recommendation. An example is mine's 137. My numbers somehow are off. I'm not sure why. I'm looking at the report, but this is a staff question. If a civil penalty is issued to a licensed dealer and this licensed dealer goes out of business, does the principal dealer remain obligated to pay the civil penalty, or by closing the business, does this relinquish his responsibility for the penalty?
Well, I think I can maybe able to answer that question. If the business, I may need to ask you a question so I understand it better. Is it basically the recommendation is to not issue a civil penalty because the business is closed?
Correct.
Yes. Well, the issue is if their business is closed, then we have limited resources as to how we would actually enforce a civil penalty against a closed dealer because they were licensed. If they were licensed at the time in which the activity occurred, yes, we could always go back and issue a civil penalty. We have zero leverage to do that. They have zero. If they've closed their business, they have zero leverage to agree to paying a civil penalty out there. And we would generally on those, we'd have to put them towards a hearing to get an order for a civil penalty. And if it's a closed business out there, again, there wouldn't be really any leverage out there in order to, and even if we had a civil penalty assessed, to actually get them to pay that towards the commission.
And I just brought that up because I see that time and again. It's not a huge deal. It's kind of a hurry baby. But I just say, for example, if I got a speeding ticket and I decided, I'm a little old, I'm going to quit driving and just not going to renew my driver's license, so they're going to quit looking for me to pay that ticket. It's just one of those things. I see it often, and it's just a
Right. For context, we do for civil penalties that are actually issued either they sign a consent order, do a payment plan, don't pay, maybe they don't care about their license, they go out of business. We have two methods of collecting those that have been issued where we actually have an order for civil penalties. Anything less than $10,000, we send to a third-party collection agency. Anything over $10,000 goes to the Attorney General's office. Okay. The third-party collection agency will make attempts to collect, just like if you had any account receivables that you assigned out there. And if they determine over a period of time they cannot collect them, they'll send them back to us and say they are uncollectible. Okay. And we're kind of stuck. Now, that dealer will have a closed and flagged on their licensing file. So if they ever attempt to come back into the industry, that will be noted and that can be taken up. Absolutely. Their license could be denied, or they could say, in order to obtain a license, you're going to have to settle this civil penalty prior to. So that is a method that we have. Very
good. That's good information. That satisfies me.
Welcome.
And Mr. Chairman, that's all I have.
Okay. Who's next?
Commissioner Galvin, I just got a couple comments. I agree with Stan. This legal report is very clean and y'all did a great job. Just a few questions. A comment on 14. Maybe I'm reading into this. I mean, apparently this dude was just so upset that he took a baseball bat and poured gas down the vehicle's tank. Am I reading more into this than what this is? I mean, why is he so upset?
Honestly, it was and it was a female. I don't know, but there's video of it and I saw it. And I can tell you it really happened. I think this was just a disgruntled consumer. I don't believe on everything that I've read that they had a right to be anywhere near that upset.
And they were pouring change down,
That's yes.
like coins, putting
Yes.
coins into the tank.
Yes.
Did they think it was Carvana or something?
No.
So anyway, that just disturbed me. I mean, it just seemed weird. The other one is on 23. And my question on this one is, and maybe somebody could help me, how do you change a Carfax report? How does somebody change a Carfax report? I'm just blown away on this.
Let me take notes.
Yeah.
Well, I mean, you can't
If
change
I
them.
could figure that out, I would tell you, but I don't think you can.
Yeah,
I think only
you can't
Carfax
change
can
them.
do that.
It takes proper documentation, especially if they have frame damage. We basically have cars that report as frame damage from time to time, and we take them to body shops and they put lasers on them, and you can change it. I mean, it can be done, but it takes proper documentation.
From who? The insurance company? I mean, explain.
No. I mean, you can go straight to Carfax and with their customer service area, and if you have something that you're going to dispute, you have to provide the proper documentation, and it can be changed. And they're very receptive to that. I'm not advocating. I'm a fan of Carfax, but because they don't always get it right, and they're not the gospel. But you can change, and I have, and we do often with 6,000 transactions and probably $7,500 purchases a year. We run across pretty much everything. So I've altered everything from odometer discrepancies, branded titles, salvage titles. I mean, there's been a lot of rebuttals to NB altered. So you can change your Carfax.
Okay.
Did you get that, Chairman Roberts?
Yes.
Okay.
And the other one is on 29. I'm just trying to figure out on 20200740031. Then at the bottom it says 2 complaints closed without action. 2014, $18,000 consent order for 2 complaints for advertising. I'm trying to find out where this $18,000 advertising is into this paragraph. Where is it? Can someone explain this to me?
Sure.
I'm not under. You're talking about the 2014 action?
I'm trying to figure out where this $18,000 coming from.
It's an old complaint from 2014.
Okay, so it has nothing to do with this paragraph whatsoever. Is that correct?
No, it has nothing to do with the current complaint. No, that's an old complaint in their history.
Okay.
We always provide that disciplinary history on every single matter.
Okay. Because I'm trying to read into it, trying to figure out how this is $18,000, but that's good information.
It is good information, and it has relevance. Yeah, for sure.
Other than that, I mean, it's pretty well plain.
Also, I changed number 13 where it says one more than allowed by law. You had a question about that.
Perfect.
Anybody else?
Mr. Chairman, may I ask a question of legal counsel while we're on this? And this is relates to Commissioner Norton's comments about advertising. Notwithstanding the schedule, the citation schedule that we have under 5517-117A, it says, in addition to any remedies provided in this part, any person violating this part or any rule is subject to a civil penalty of not less than $100 nor more than $5,000 for each day. So could we not make the case in terms of these advertising violations, that we could penalize them up to $5,000 for each day or act as a violation. Is that an accurate statement?
You can. We've done that. We have done that before. When it had to do with like advertising, of issuing an advertising, I think when we did a civil penalty that high, it's that we provided them with previous notice that advertisement was a violation, and it clearly was a violation. If they intended to do it more, that we could do up to $5,000 per violation per day.
Okay,
This is
thank
per
you.
violation per day. I think at one point in time, I think there was 120. I remember a case where we had 120 advertising violations over the radio that was substantially egregious, and they wrote the commission a check for approximately $60,000 for $500 per violation. But that was very egregious.
Well, and I ask because, as Commissioner Norton mentioned, we're seeing more and more of these advertising violations, a real uptick in them. So I just wanted to be sure I understood that. Thank you. I apologize for interrupting.
No, this Commissioner Norton, I appreciate you interrupting. I noticed there were four citations in this report addressing that. So I see there's activity on it, and we certainly appreciate that, because it's still a very unlevel playing field. And I might add, what that cost our company last year was approximately $3 million, and we have our competitors next door and down the street not compliant, and it's disconcerting to say the least. But thank you for addressing that.
And I would love to add that this is the first legal report, at least since I've been working for the commission, that we went from doing a letter of warning for the first advertising violation. And I know we had talked about it, and this is where we're doing a $250 civil penalty for the first advertising violation. So that's something new.
Good.
And whenever there's no more questions, I just have a couple updates on a couple of my cases
Okay.
when that's appropriate.
Go ahead.
On number, let's see, 139, and that would, it's the first complaint number under that. It's 2019-023-651. I spoke with the complainant since this was submitted, and the complainant is the respondent's cousin and does not want to move forward with giving any sort of testimony or being involved in this, and wants the complaint closed. So because we have other matters that I can move forward with, I would like to change that recommendation to close for just that. It's complaint 2019-023-651 on number 139.
Yeah.
And then
We're closed, right?
one more on number 96. I have received proof of the active county business license, so I'd like to change my recommendation to a letter of warning. And that is it.
Anybody got any problem with?
Commissioner Norton, I concur.
Okay. And Erica, you're making notes on all these changes, right?
Yes.
All right. Anybody else?
I have one quick one. On 121, it's a similar typo as to 13. I think it's supposed to read 3 more than allowed by law on the temporary tags.
I'll have that changed. Thank you.
Okay. And then on just a question on number 12, seems to be another pretty disgruntled person, but the allegations are so serious. Is there any proof at all or any evidence that they've submitted to support their allegations of criminal activity and everything else?
No, there's not. There's no proof of that fraudulent activity.
Okay.
Yeah, and Mr. Levy, I could add to that is that I know that this respondent over the years that I've had the commission has had allegations, not of that nature, but complaints. And I think one of the things that they do is they rebuild tractor trailers and they sell tractor trailers that are rebuilt, and they're appropriately priced as a rebuilt tractor trailer, and a lot of the purchasers are out of state that feel that they did not realize that they were at the time rebuilt tractor trailers. But over the years, those complaints had generally been closed by the complainant because they had amicable agreements between the two. So they didn't move forward with it. But we have had complaints about them over the years. But their business model has kind of been the same that I've noticed over the years. So I kind of had concerns when I looked at this also. But I think those allegations are far fetched from what we've historically seen in the past, and I agreed with Stuart on that.
Thanks. That's all I have.
And Mr. Chairman, at the appropriate time, I'll just quickly address the last one, number 148.
Okay.
Number 148 is being presented to you all, which is a complaint from a franchise dealer against a manufacturer regarding allegations of violations of certain specific laws that we've already addressed that you can read there in the report. And so my recommendation on this is that you'll see down there to explain it is that we already have documentation from both sides as to their positions on this matter. Their filings are similar to court filing documents, and I feel that my recommendation to move forward is that we file everything that's been provided to the commission at the Administrative Procedures Division within the Secretary of State's office, which would initiate a formal hearing before the commission, and that my office would work with the administrative law judge assigned to it, which would, in my opinion, allow the manufacturer and the dealer to have a hearing before the commission on this matter, since they have provided voluminous documents to us regarding these allegations, and then our office would sit to assist in facilitating the hearing before the commission, but not to necessarily be a part of the adversarial proceeding, such as against the manufacturer. So that would be what my recommendation is on this matter to move it forward so that it can have progress within this committee.
Thank you. And I concur that it was written very well. And thank you for your comments. Anybody else got any comments? Denise, what do we need to do now? This is my first time chairing the Legal Review Committee. So do we need to adopt it?
I think we need to adopt the amended report, and I'll call the roll.
Okay.
So if you will make a motion to do that, Mr. Chairman.
Okay, I'll make a motion that we adopt the Legal Review Committee changes.
Second, Commissioner Galvin.
Okay, and I will call the roll. On adoption of the legal report as amended, Commissioner Levy,
Yes.
Commissioner Galvin,
Yes.
Commissioner Norton,
Yes.
Commissioner Kramer,
Yes.
votes aye, and Chairman Roberts
Aye.
votes aye. Mr. Chairman, you have 5 ayes and 1 absent.
Any new business in the Legal Review Committee? Any old business? If not, we can move for adjournment.
Motion to adjourn, Commissioner Norton.
Second, Commissioner Galvin.
All those in favor, if you'll call the roll.
Motion to adjourn, Commissioner Levy,
Aye.
votes aye. Commissioner Galvin,
Aye.
votes aye. Commissioner Norton,
Aye.
votes aye. Commissioner Kramer,
Aye.
votes aye, and Chairman Roberts
Aye.
votes aye. Mr. Chairman, you have 5 ayes and 1 absent.
Okay. Well, it is 9 o'clock, and we will reconvene for the quarterly meeting at 9:30. Don't get lost.
Are we on the same? We will be on the same login.
Yes.
Yeah.
Yes, sir.
All right, good. Thank you.